Someone make it make sense.
Probably a couple.
Hello, everybody. Big day here for those of us who are trial watchers, right? We had a lot going on today. And I've been trying to keep up. I've been having lessons, and I know there's just been a lot of things happening, including huge document dump, as they say, out of Delphi. Incredible things there. And also we do have news for Idaho with Brian Kohberger. Shout out Flash Fan. How are you feeling, my friend? Are you doing any better? Were you able to do your stream for the Melanie McGuire through your Discord? I haven't even had a chance to check, but you may not have been feeling up to it. But happy to see you. I figured, yeah, you don't want to miss this, right? So yeah, I hope you're feeling better and getting some rest. Did you eat your celery last night with chocolate? Shout out to Turning Over Every Stone. Happy to see you again. I remember you from last time as well. We do have a couple new Nightbot commands. Let me see. There's one of them that is like, let's see here, if I can remember it. Let's try this one. We do have a number of school friends who have not been feeling so well, including Flash, but also Iowa and Candace. And so I added another command for that as well. There we go. Yeah. Excellent. Cute. Thank you, Nightbot. That is so cute. Shout out to Twizzlestick. Hey, by the way, speaking of new commands, Twizzlestick, I went ahead and made you a command, and just tell me if you hate it or not hate it, but let's try it and see what you think. Twizzy into hizzy. There's a little house. Oh wait, we have to do this if we're going to talk about houses, don't we? Don't we now? Don't we? Hold on. Oh, where is it? Oh, here it is.
It's a house.
Woo! Awesome. Glad you like it. Wonderful. Wonderful. And for anyone else who's new but is becoming a regular part of the school crew, of course, everybody gets their own custom command if they want one. So y'all just let me know, and I will spread the word to Nightbot, and he'll get it set up for you. So the plan for this is we're gonna briefly, quickly just go over what what has happened today for Idaho. It won't take long. And then we're going to go through these last Shanna Gardner documents. And then this should redirect you guys automatically into the next live stream, which will be the Katie McVanoa proffer. So that's Adelson, Dan Markell case. So I've got all of those. And so we're going to take a look as well at that. And okay, so we are going to first start here. So brief recap here, guys. So the things that what matters to me here, right, is like, what are the things that we were waiting for Judge Hippler to rule on, right? Like, as we say, like, he hasn't closed the loop on it, right? So we've still, and I was mentioning this last night, but we still are waiting on an actual order, either granting or denying the motion for the Franks hearing. That has not come out yet, okay? And then the other big thing that we were waiting for an order on, going in chronological order, right, was this motion to unseal IGG suppression briefing and hearing. So we've already covered all this, but I wanted to just briefly remind ourselves what it was specifically that the defense was asking for, right? So what the defense specifically was asking for was for these briefs, right? So, and these, again, were all related to the motions to suppress, and they're listed in this footnote, right? So, yeah, okay. Those exhibits. But the related hearing, this is the part that matters, right? The related hearing is the hearing that has not happened yet. Okay. And you guys will see that here. Right. So the upcoming hearing on the 23rd or 24th, right? So what's interesting is like oftentimes, you know, what we would see is we would see a motion or an order or whatever, like previously in the docket, right? Like, let's take a look. Like normally we would see that separate, right? Like, you know, order sealing hearing, right? Like, or, you know, whatever, like they, yeah, it would be really, it would be its own separate document, right? Or own separate pleading. So it is interesting that they just included that, the defense did. And I mean, I wonder, it's interesting, right? Because by bundling them all together, it makes it a little bit different, right? Because really, in my mind, even though they're related, it would make sense kind of to make motions separately, right? Just in case Judge Hippler might want to grant one and deny the other, right? Just in case, right? But they're all bundled, right? In the way that this is filed, okay? So, and I mean, why did they do it that way? I don't know. Did they assume he was not going to do this? Did they assume he's not going to grant this? So, and we were talking about this last night, right? We were saying that Judge Hippler is going to have to rule, right? Judge Hippler is going to have to rule on this. We were saying it would probably happen today because it has to be before the 23rd, right? He has to rule on this before the 23rd, which is why I wanted to start by mentioning what don't we have rulings on yet? Okay, so now going back to the docket, the only thing that came out since the 15th on here, right, is this order governing the proceedings. So again, still no actual written order on granting or denying the franks, and still no written order on granting or denying the motion to unseal the briefing and hearing. But we have this order governing proceedings. So we'll take a look at that next. Naturally. Hey, are you still streaming or not, Keen? And I'm sorry I wasn't able to jump on. I ended up having way more lessons than expected, which is why I had to push everything back. So, but I hope your stream went well, and thank you for inviting me. I'll definitely be a guest, though, hopefully next time whenever you have one and want to have me on. I don't know what I will do, but I am always down. Well, he has to, okay, I see what you're saying, so that we won't see anything until after it's done. But he has to still rule on whether it will, okay, let me show you what I mean. Okay, so remember, a motion is you're moving the court for something, right? So where is the initial? Right. So you have the motion, oh my God, motion for the Franks hearing, right? They're asking the court to do something. So before that can even be scheduled, right? Things will now happen, right? There's going to be, and these already happened, right? The state objected, the defense replied, right? And either the court, right, can just, without oral argument, they can go ahead and grant or deny a motion, any motion, including this one, or they can be scheduled to be for oral argument, and then they can, grant or deny. But the thing is they have to first grant or deny it for it to even happen. So I think that we can't put the cart before the horse, right? Like, we don't know, we officially, we don't know yet, because he has not on the record granted or denied it, right? So if it will even happen. So so that's kind of what I was saying. Hopefully that makes sense. Oh yeah, I'm basically Gandalf. I'll take that as a compliment, I suppose. It's private. Oh, okay, interesting. Okay, so I don't know. I don't know how that affects the streams, but yeah. Hopefully it went well, and I'm sorry I couldn't be there, but definitely next time. And again, for Twiz has a new command. Anyone else who wants a custom command, let me know. What did Frank do this time? That's hilarious. Okay, so hopefully that makes sense, though, about why I think it's interesting that we haven't seen a ruling on this yet, right? This motion was made, right, on November 14th. Okay, so now, we will go to here. So again, the last thing that came out on the docket prior to this was the notice of a hearing, right? And so now, but this is where we get a little bit more information here. Order governing the proceedings for January 23rd and 24th hearings. Okay. The hearings set for January 23rd and 24th in this matter will proceed as follows. Starting at 9 a.m. on January 23rd, the court will take up testimony related to the defendant's motion to suppress re IGG. And so let's just to make sure no one's confused. This is not, because there's so many motions and related to IGG, this is not the motion to unseal the documents, right? This is the motion to suppress from November, right? The motion to suppress re IGG and the defendant's motion, and there it is, and they'll take up testimony. So now we understand, this is why I wanted to go in order, right? So now we understand why. Remember how I said they can either rule or they can say, we're going to hear oral argument and then I'll rule? This is why I went in chronological order. So now we know why we haven't seen a ruling either granting or denying the motion, because they're going to have oral argument first. So now it's going to make more sense there. So testimony related to the motion to suppress IGG and the defendant's motion for Frank's hearing, insofar as it regards to the IGG investigation. So that makes sense. In a way, it was smart, because Judge Hippler's like, we're going to just, I hate the saying, kill two birds with one stone, but whatever, be more efficient, right? If we're going to be arguing the IGG motion to suppress, right? And then we're going to, and so now it makes sense as to why we haven't seen a ruling on the Frank's hearing, right? Because he wanted to hear it. So as indicated in the court's oral ruling, this portion of the hearing will be closed, sealed. Footnote 1. The court's oral ruling will be followed by a written order. So what does this mean to me? This means to me, it's not, what can we infer from this, right? Like, he's not, without seeing the order, because he hasn't written it yet, but what we can infer from this is that this essentially is denying the this, right? Now, again, the reason I say we can't say 100% is because he's talking about the hearing, right? And remember guys, when I said it would be different potentially had they filed this as two separate pleadings, right? Like I said, the briefings as one pleading and the hearing as a separate pleading, because what we're seeing here, right, is that the hearing, right? So let's not lose hope yet, is my point. This portion of the hearing will be closed, sealed. But there is still hope for the briefings, right? Because again, we don't know. And I wouldn't be surprised if Judge Hippler comes back and says, hey, defense, you need to make these separate. Because to me, that just makes more sense. And that way he can rule on them separately. What you don't want, right? What you don't want, if you're the defense, what you don't want is, because you made it all in one motion, right? And because he wants the hearing to be sealed, what you don't want then is for him to only have the option to just deny the motion, and therefore it will also deny unsealing the briefings. But had he filed it separately, maybe he would have done that differently. Does that make sense? So I'm just taking a look. So what have you? I'm glad you guys are there. Everyone's saying that that Kane's lives are fire. That's awesome. Happy about that. Oh, and it looks like you had some other guest on. Okay, that's good. Awesome. Okay, cool. So, but does that make sense to you guys? How, like, it would be a shame, right? If, like, the entire motion has to be denied because of the hearing, and then the briefs will not be unsealed because of that, right? So, okay. So, and the reason, again, I'm mentioning is because right here, this portion of the hearing will be closed, sealed, right? So, okay. Following the close of this evidence, the court will take up the following matters, which will be live streamed on a feed available to the public. Footnote 2. The trial court administrator will cause a notice to be sent to media and public via Idaho Supreme Court's social media accounts, advising when the closed proceedings have concluded and estimating when the live stream proceedings will begin. And I'll go and read the third footnote. The courtroom itself will not be open to the public because of the need to revert to sealed proceedings on and off throughout the hearing, which is interesting as well, right? I get it, but it's not a good look, right? Like, I don't know. I mean, what they've done in the past, right, obviously, is discussed the things that are more than likely going to need to be sealed and then just grouped them together, right? And that way you can, unseal the hearing and then there you go. Anyway, so, okay, so now, subject to the court's determination to close any portion of the hearing by turning off the live stream feed as necessary. So testimony. So in other words, these are the following matters now, right? Testimony related to the defendant's remaining motions to suppress. And by remaining motions, he means other than IGG and motion for Frank's hearing. Arguments on defendant's motion to suppress and arguments on the defendant's motion to compel. So what we can expect is the closed portion that will happen, right? They're going to do, again, the motion for the IGG and the suppress IG and then the motion for the Frank's hearing. So we won't know what's discussed in that until after these hearings when Judge Hippler has a chance to make a written order. And then that's when we will know if he's granting or denying the Frank's hearing, unless they happen to mention it later on, contemporaneously during the other motions to suppress that they mentioned, oh, we're going to have the Frank's hearing, you know what I mean? Or maybe it'll come up in scheduling. But other than that, we would be getting an order. But because they're hearing all the stuff back to back, it's not going to come out and because there's no public there, right? I just don't think we'll have any way of knowing what goes on for that until the orders come out. So, so arguments on the defendant's motion to compel. So motions to suppress and the motions to compel. This motion to compel was, what was this for again? Let me see. Oh yeah, that was to compel. That's this motion, just to refresh our memories, because there's been so many filings and this was a while ago. This is from December 27th. So this motion to compel, right? This is for the expert witness disclosures. This shit was insane, man. This shit was insane. It blows my mind that they didn't include expert witness reports and all that. Okay, so that's right. God, I forgot. That was a whole other issue. Okay, so there's a lot of things. I mean, is 2 days going to be enough? I don't know. There's a lot to go over, right? A lot to go over. So, and the other thing too, right, is remember, we've got all these subpoenas that have been issued. There's going to be witnesses. This is going to be insane, you guys. This is going to be fucking insane. And that's it. That's that. So, and one thing I'm wondering is how this is going to be dealt with the streaming, right? Is this going to be one of those things where it's only through and I don't know if any of you guys know in the chat, is this going to be through the court's YouTube thing? Is going to be like it used to be where you can only see it while it's happening. And then once it's over, it disappears. I did check on Court TV and I didn't see an upcoming feed for it. Because that's one reason why it might not be advantageous to cover it live, because if you pause it or rewind it or anything, once it's over, because that had happened before, then once it's over and they pull it down, then that's that, right? You don't have it. So I don't know if any of you guys know what the deal is. Shout out to Black Witter. Oh, what? You played that is I don't even know what to make of this. Kane said that they played you're talking about the Shostakovich. That is, I don't even know what to people were probably very confused. But thank you. If anyone wants to know who Shostakovich is, let me know. Yeah, they don't leave the hearings up, right? But sometimes though, it's it's still there through Long Crime and Court TV and stuff, right? So there was there were a couple hearings where that wasn't the case, and then it changed to where you can go back and watch the other hearings. In other words, they're given access to the court feed, so that way if you watch it through one of those places like a Long Crime or a Court TV, you're not fucked, basically, if that makes sense. So yeah, but and the thing is this too. I don't know. I don't know. Let me know what you guys think. I know there's gonna be like a million people streaming this live, right? I don't know yet what I'm gonna do. If I could stream it, Thursday and Friday. I could do it live. But again, I don't want to be in that position, where you have to try to keep up with the feed so it doesn't disappear type thing. But also I know there's gonna be tons of people streaming it. So I don't know. I haven't really figured that out yet. But yes. So thank you for that. So yeah, but one last thing to look at, and then we'll move to Shanna Gardner. So the last thing to look at is this. So this is where it gets interesting. So in the case summary, guys, so here's the deal. There's some things here that have not come out for us to read, but they exist. So those would be, so we're going to get some information here, right? So we know there's been these subpoenas issued, and then motion to redact or seal, whatever. But here's what we're waiting on. Okay, that should pop up on the docket. The objection to the defendant's motion to unseal the IGG suppression briefing and hearing. Can't wait to see that. Okay. And there's also the defendant's reply. But this is the part that's interesting, guys. I don't know if anyone's even noticed this. Look at this. What do we make of this? Motion to be heard as interested parties. And then there's a memorandum in support of motion to be heard as interested. And here's why I'm mentioning this, because this is not sealed. This is going to pop up and we will see what the fuck this is about. And I'm like, what? I'm so curious. Let me explain why. Because this is not typical. And examples that we know of from other that have happened in the past in this and other cases. For example, in Det v. Heard, there was a motion to be heard as interested parties when it came to like TMZ. And then I think there was another third party. And it was like in the middle of trial, and they came in and had like a little mini trial within a trial with these third parties. And then this also has happened, pre-trial in this case with the media. And this was from like the summer of 2023, maybe? I don't know, 2022 or 23. 2023, yes. And if you guys remember all that business, right, about cameras in the courtroom and all that, right? So, and there's other examples too, but those are just some examples. So, but who is it? Who is it, guys? What do you think? I'm so curious. And the timing of this, right? My thought is that they want to be heard at these hearings. Who is it? So in other words, this is an interested party. So this would be a third party. What they have to, and the reason they have to make a motion to be heard is they have to show that they have an interest, right? That they need to be heard. So this is not defense. This is not the state. Who is it? I'm so, and to that end, potentially it could be the media, right? Like the example I was just saying about from earlier in 2023 in the summer, right? Maybe it's the media, right? And maybe that's what it is, because remember the public not being allowed at all. Like I wonder if that's what that's about. And this is why I'm saying is 2 days going to be enough, because if they're going to do all this, like y'all. So we can, again, things we can be looking forward to pop up. It could be any minute, right? The objection to the defendant's motion to unseal the IGG shit. There's this motion to redact or seal newly filed records, which is just going to say that it's going to be sealed or redacted. So whatever, that's not something I'm too excited about. But then again, we have the reply to the state's objection. And then we have the motion and the memorandum for this interested parties. Okay. So that's 4 documents to look forward to. And then that can pop up any moment. And then we have, of course, here, the motion hearing on the 23rd. Who is Maddie Mayer? Heather says media. Yeah, I think that's that's a safe bet. Like as I was asking the question, and then I like answered it in my head, and I was like, oh yeah, it's got to be the media makes sense. Again, because just like the example from the summer of 2023, that's got to be what it is. Because this was the thing, right? Remember, I was like, this is not good, right? Again, it's like I get it, right? But also there's ways to do this, and they've done this before. They've done this before where anything that really needs to be sealed, you just group those together, right? But this is a big deal. And Vinnie Politan made a great point about this as well. And we watched those clips last night too on Court TV. You know, it's so, yeah. Oh, okay. Okay. Gotcha. Yeah. I don't know. Yeah. I don't know if that would be, I mean, I'm not saying that couldn't happen, but I don't know if this would be the timing for it, just due to the nature of what these hearings are about. And then the time, again, think of it, right? The timing, right? This is what I was saying too, right? Go back to this, the timing of it, right? Because what happened was you had, where is it? The timing being that it happened right after the order came out, right? The what did he call it? Order governing the proceedings, right? So so it's like, I would imagine as soon as the media saw that, they filed this shit. And they probably had it ready to go just in case, you know what I mean? So yeah, so that's it. So that's everything so far out of Idaho. I'm going to refresh this just in case any of those ones popped up. It is 2 hours earlier in Idaho, and this is digital, so you never know. No, so we will keep an eye out. Okay, so now on to Shanna Gardner. So let me unshare, reshare. Okay, here we go. All right. Excellent. So this is our last installment of the death penalty motions here. And for anyone who hasn't seen the other installments, you know, there were 13 motions filed on Brian Kohberger's behalf as it pertains to the death penalty. And in Shanna Gardner's case, 14. So one more motion. Not that it's a contest, but it's just funny because I just count just because, you know, I don't know, I just do. Okay. So this last batch is really interesting. This batch is as it pertains to the recent change in the legislation in Florida, which Kane, I'm sure you have thoughts on this, but yeah. So yeah, let's just jump right on in. So, all right. And this was filed on November 26th. Okay. Here we go. This is the part that's interesting. So Florida statutes, which governs capital sentencing proceedings in the state of Florida, was amended by the Florida legislature in April 2023 to no longer require unanimity for a jury's verdict that a defendant should be sentenced to death. The governor signed the bill into law on April 20th, 2023. The bill signed into law by the governor provided. And remember, we've talked about this before, but just to recap, you know, of all the states that still utilize the death penalty currently, all of them require it to be unanimous except for 2 states. And that's Florida and, oh, fuck, what was the other state? Now I can't fucking remember. But it was Florida and one other state, and both of them were 10 out of 12. But Florida said we're gonna put ourselves in a category of our own, and we're gonna change it to 8 out of 12, which they did. So the bill signed into law. Florida has a specific statute that governs the applicability of amendments to criminal statutes to criminal cases pending. Oh, right. This is interesting. So here we go. Let me not blah, 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 blah. Let me actually read this like a person. Let's try this again. Florida has a specific statute that governs the applicability of amendments to criminal statutes to criminal cases pending or criminal acts or omissions committed prior to the effective date. This is what, prior to the effective date, right? April 20th, 2023. Prior to the effective date of an amendment. Florida statutes is titled Effect of Reenactment or Amendment of Criminal Statutes, reference in criminal statutes, and provides in pertinent part. Okay. Except as expressly provided in an act of the legislature, the reenactment or amendment of a criminal statute operates prospectively and does not affect or abate any of the following. A, the prior operation of the statute or a prosecution or enforcement thereunder. B, a violation of the statute based on any act or omission occurring before the effective date of the act. A prior penalty, prior forfeiture, or prior punishment. So this is huge. Why? Because this happened, this change in the legislation, this happened after the crimes that Shanna Gardner is being charged with. Okay, so the term criminal statute, okay, we don't need to define that part, but this is bold underlined. So dealing in any way with a crime or its punishment, defining a crime or defense to a crime, or providing for the punishment of a crime. Thus, the legislature's amendments operate prospectively to acts or omissions occurring after the effective date and do not change the applicability of the section, which was in effect on the date of the alleged first degree murder. So when the legislature amended the section, right, in April 2023, dispensing with the jury unanimity requirement or placing it with an 8-4 vote, disgusting. It did not choose to apply its amendments retroactively, right? In other words, it did not expressly provide that the amendments applied to those penalty phases then pending. So yeah, this interpretation is consistent with the legislative intent because the effective date language in the statute and lack of retroactivity language in the statute makes it clear and obvious that the intent was not to apply the amendments retroactively to pending capital cases. So just citing some more case law here, but that's the point. It's a good point right here. So to the extent this court believes that the language is susceptible of differing constructions, which I don't know how it could, it's pretty clear, but should they? The law provides that criminal laws shall be construed most favorably to the defendant, right? Construing the effective date language of the amendments favorably to Ms. Gardner means that if she's convicted of first degree murder, she's entitled to a crime of a jury unanimity in any verdict imposing a sentence of death. Ms. Gardner notes for the court that this issue is pending before the Florida Supreme Court in Michael Jackson v. State, and also some other cases. So in other words, because of course she would not be the first case where, you know, the prosecution is seeking the death penalty, but the crime happened before the change in legislation. So there you go. Document one down. Next up, we got Defendant Shanna Gardner's motion to preclude application of the most recent amendments. Again, this is still dealing with the change in the legislation. So again, April 20th, 2023. And here's the procedural history, right? So effective of March 13th, Florida's capital sentence scheme statute required jury unanimity. I don't know why it said it was 10 to 12 at some point, but anyway. And then Bridegan was killed on February 16, 2022. More than a year after Bridegan was killed, the governor signed into law. And then here it is, disgusting. If at least 8 jurors determine that the defendant should... I mean, y'all... Yeah, okay. Finally, unlike most statutes passed by the Florida legislature and signed into law by the governor, it was to take effect upon becoming a law. So now there's some more. So basically the same issues, right? But now we've got some more argument here. The state may not rely on a classification whose relationship to an asserted goal is so attenuated as to render the distinction arbitrary or irrational. The change in Florida's capital sentencing scheme requires a less than unanimous jury verdict for a death sentence to be imposed by the court. And if that is applied to Ms. Gardner, it's entirely arbitrary. There are a multitude of reasons why Ms. Gardner was not arrested in 2022, namely that the evidence against her was and remains scant. Oh, I see. Okay. Distinction to be made here. Right. Okay. Distinction to be made here. The crime happened in 2022. This is interesting. Okay. The murder happened in 2022, right? But Shanna Gardner was not arrested. Interesting when you think about that, right? I wonder if that's, think about that. She was arrested, right? Or indicted in August of 2023 after the change. That's wild. That's wild. Wow. How interesting. So, right. Fuck. Now, having said that, another interesting point, right? Like for Mario, right? He was indicted prior to the change because he was in March of 2023, a month before. Shanna was in August of 2023. after. Interesting. But the crime, of course, like I said, was in 2022. So that's what they're pointing. Interesting. Okay. Interesting. So, wow. Okay. So in other words, if there was a legislative bill on the horizon that made it easier for the state to obtain a death sentence, prosecutors and law enforcement would be incentivized to delay. Literally, that's what I was just implying. Literally. Keep reading, Chelsea. Right? That they could be incentivized to delay. Yep, until the new statute's in effect. Interesting. Which would be why, right? You need to go off of when the crime occurred and not when the arrest happened. That's exactly it, right? There it is. There it is. Bam. Timing of arrest, indictment, and trial are clearly arbitrary bases to distinguish a citizen's entitlement to safeguards against a death sentence that and violates equal protection. I think this is really interesting. And again, also too, because this is a difference between Mario and Shanna. Really interesting there. Okay, next up, document number 3. We're moving right on through these, guys. This is 303 pages long, but I'm sure a lot of this is the supporting, case law, probably some legislative history. So, okay, again, this is all the same as before here. We know the new law. Okay, state of Florida v. Victorino and Hunter is not precedent. Okay, so to be clear, the Florida Supreme Court has yet to address the applicability of the amended statute to offenses committed. Again, like this was in, I think, the first filing of this batch, that it's still being there. It's still being discussed at the Florida Supreme Court, right, in terms of this issue, which is that's a good grounds for this motion, right? It's a good argument. So to the extent this court even considers the Fifth District Court of Appeals views on the subject of applicability of the new statute of pending capital cases, this case that's pending involved resentencings for crimes that occurred in 2004, or not pending rather, but the case law they're referencing. So as such, the 2023 statute now in effect requiring at least 8 jurors to recommend a death sentence could be seen as ameliorative in light of the statute in effect in 2004. Okay, I think what they're saying is like they're using the example of what happened when they changed it in years prior and how that was dealt with. In this case, Ms. Gardner's alleged first-degree murder occurred while the 2017 version of the statute, right, that required jury unanimity for a verdict to impose death sentence was in effect. Further, there was absolutely no constitutional infirmity with respect to the capital sentencing scheme in effect in 2022. For Ms. Gardner, however, the 2023 version makes it easier for the state to obtain a sentence to death than the statute in effect at the time. Yeah, absolutely. Yep. I mean, this is important, right? Like not just for Shanna Gardner, but for other people, because this is, again, it's a matter that really hasn't fully been, again, it's still there. They're still figuring it out in the Florida Supreme Court. And, of course, then things that happen become case law, and then it affects people going forward. So, so procedural history, just as I figured here. So, and there it is, August 17th, 2023, she was indicted. Yep. So the ex post facto clause bars this court from conducting the penalty phase under this new statutory scheme. So, and I figured this is what this was going to come to, right? The right to a unanimous verdict has been characterized as substantive by the state and federal courts. Moreover, specifically in the context of the death penalty, the Florida Supreme Court's opinions with regard to jury unanimity cases indicate that it too thinks that an alteration of the life or death vote breakdown necessary to impose a death sentence is a substantive change in the law that can only be carried out by the legislature, who has the sole purview to enact substantive changes of criminal laws. So why does that matter? Because the governor signing a bill into law is different. Finally, we express our considered view. So this is from urging the legislature to add a unanimity requirement to Florida's capital sentencing scheme. Finally, we express our considered view as the court of last resort charged with implementing Florida's capital sentencing scheme that in light of developments in other states and at the federal level, the legislature should revisit the statute to require some unanimity in the jury's recommendations. Sad that they even have to say that, right? Incredible. And other people joined in agreement. I mean, I don't know how you cannot be in agreement, but that's just me. So, yeah, the court is well aware that under separation of powers doctrine, yep, matters of substantive law are for the legislator. So this is exactly so funny. This is exactly where I saw this going. And that's why I said, right, I just pointed out the distinction that the change to this, to the statute, right, 484 was signed. It was a bill signed in by the governor, not done through the legislature. So this is exactly where, that's why I mentioned it. And now we're going to see this here, right? Yep. It's for matters of substantive law are for the legislator, while matters of trial procedure are for the courts. This provides a clear indication that the Florida Supreme Court itself considers unanimity or non-unanimity in a jury's vote regarding the appropriate punishment to be substantive. Otherwise, the Florida Supreme Court would have adopted and repealed the unanimity requirement themselves instead of urging the legislature to do it. Nobody is claiming that that statute was unconstitutional or that the legislature and the governor changed it because it was constitutionally infirm. In other words, while Mr. Daubert was trying to avoid facing a death penalty proceeding completely, Ms. Gardner is asking this court to apply the law in effect at the time of the alleged capital offense. So they were just referencing here this other case where this other fellow, Mr. Daubert, wanted to use the change in the statute to just like remove the death penalty. And they're saying, which, I mean, they've already made their motions to strike it, right? We already covered this. But they're saying, look, we're being more reasonable here. We're just saying, please apply the appropriate law that was in effect at the time, which, you know, so there you go. A lot of this will be dealt with in oral argument. And in case you're wondering, well, when is that going to happen? Don't worry. Right before I went live, I checked the docket to see if there was anything else for this case. And I will show you guys the most recent filing that we have. And no, there's no other, I didn't see any other upcoming hearings scheduled or anything like that. But but this will happen, and we will cover it, of course. But let's jump on to the last one of this batch here. So and then yes, of course, right. A motion to declare the recent amendments to the statute unconstitutional. Yeah, I mean, a lot of this I feel like we can probably intuit because it makes logical sense. That it's unconstitutional, but yes. But as far as how they're going to argue this to the court, right? As this court is likely aware, the Florida Supreme Court has refused to provide clear guidance regarding the applicability of the new statute, again, because it's still being dealt with in the courts there. So, well, and again, a lot of this is sort of the same. Introduction. Okay, so it violates the Eighth Amendment because it lacks adequate safeguards to prevent arbitrary death sentences. So again, we won't read all these because they will be discussing this at oral argument. But what we'll do is we'll go through what are their arguments here, like lacks adequate safeguards to prevent arbitrary death sentences. So there's that word arbitrary. We see that a lot as it pertains to death penalty motions. All right, the next one, proportionality review, which has now been abandoned, was an important safeguard against arbitrary infliction of the death penalty. And that's interesting. So there's an overlap here with how this was discussed in Idaho when we covered all the death penalty motions there for BK. But there's an overlap here. They talk about the narrowing a lot, right? It's a similar thing, right? You have to distinguish the worst of the worst, so to speak, which is a thing in and of itself, right? So this is a similar thing. And then the next one here, the Florida Supreme Court's abandonment of proportionality review at a minimum left Florida scheme dangerously unreliable, if not outright unconstitutional. And then next, the 2023 statute is inconsistent with the evolving standards of decency and therefore violates the Eighth Amendment. Again, we saw that brought up as well in Idaho. And then we have the statute downplays the responsibility of the jury. This was talked about as well in previous, I think this was on part 2, we covered this. The responsibility of the jury. That came up a lot in the, again, I think it was part 2 of the death penalty motions. They had a whole lot, they had filings dedicated specifically to this issue, so we covered that. The 2023 statute violates the Sixth Amendment right to a unanimous jury sentencing in capital cases. History shows that English and American law guaranteed the right to jury sentencing in capital cases, and that this right included the right to a unanimous jury. The jurors of common law England decided whether capital defendants would live or die. So now we're going back to the history of in England. Love this. Oh my God. Okay. Historian Thomas Green has demonstrated in his authoritative analysis of early English juries that as early as the 13th century, by the way, I'm a huge history nerd, and this is my favorite time in history, medieval and Renaissance, 13th century, that was a good one right there. Man, shit was going down. Shit was going down, y'all. Anyway, this makes me really excited. So as early as the 13th century, jurors refused to convict on capital charges when they believed the crimes were unworthy of execution. So like jury nullification. Interesting. Those who were acquitted were released. The guilty were hanged almost immediately. Yeah. I mean, really, it was also beheaded probably too. Yes. Y'all, Middle Ages. I couldn't be happier right now. Fuck yeah. One of the tools at the jury's disposal. By the way, I have so the first ancestor to the violin is called a Rebec, Rebec. And it was first mentioned in the Canterbury Tales. And it is, speaking of Middle Ages, right? It is basically a medieval violin, and I have one. So I also, this is just nerd on a different level, but I also have like extensive training specifically in early music, which is medieval, Renaissance, Baroque, where you exercise what's called historical performance practice or historically informed performance practice, which means you're either going to be using the actual replica instruments from that time period, or you are going to use at the very least informed approaches to the music. I could go on and explain all that, but I'm sure nobody cares. But interestingly enough, what's really funny is my quote unquote modern violin, like as in my violin that I play on, like for regular music, is from 1757, which is 7 years after Bach died. That's when my violin was made by a German maker. And there's a book that is like the art of violin making, and it goes through different periods of time, and then it goes through different makers. And when you go to Germany, my violin is the example in the book, and it has the violin. And anyway, yeah. So 1757, 7 years after Bach died, before America. It's older than our country, right? It's older than the USA. Before America was a country, my violin and it's right next to me. It's right next to me as I stand here. But yes, okay, Middle Ages. So one of the tools at the jury's disposal in the Middle Ages was to decide if a homicide was committed in self-defense. That is insane, y'all. Look at this. Wow. I'm going to read that again. One of the tools at the jury's disposal in the Middle Ages was to decide if a homicide was committed in self-defense. Incredible, right? Think about that. I mean, I'm sure you are. That is so interesting, right? Wow. And here we are today. A powerful means of saving the accused given the lack of gradations of homicide in this era. Gradations as in different levels like we have now, right? Examining the ancient verdicts, Green found that the frequent recourse to such findings resulted mainly from the jury's desire to save the lives of defendants who had committed simple homicide. The juries did so to limit homicide convictions and thus executions to the most culpable homicides. And now you can see where this is headed. This is funny. So the local community in the Middle Ages considered execution appropriate mainly for the real evildoer, the stealthy slayer who took his victim by surprise and without provocation. Sorry, they said surprise, so I have to do this. Speaking of a surprise, like, I don't know, like maybe, I don't know, like a poot surprise. Were y'all surprised? Okay. The jury later found a tool in the benefit of clergy, originally designed to try and punish the ordained clergy in the church rather than the secular courts, but eventually extended in the secular courts to anyone literate enough to recite a Bible verse. Amazing. The jury's role was to decide if the crime committed qualified for the benefit, which would result in branding the convicted person and imposing a year's imprisonment, branding them. In the case of homicide, that meant deciding whether the crime was manslaughter. So this is really interesting. And even if you're not a history nerd and you're like, what the fuck? Like, as you can tell, I get really excited by this. But beyond that, why does this matter, right? Because this is, I've heard a lot of death penalty motions, but this is really, I appreciate this because this is walking us essentially through how did we end up where we are today, where we have all these different, like the rationale and the thought process as to how do we end up with first-degree murder, second-degree murder, manslaughter, all the different levels, as you guys are well aware. How did that? And this is it. This is how, which is interesting. See, in the case of homicide, that meant deciding whether the crime was manslaughter, eligible for the benefit, or murder not. As jurors recognized that benefit of clergy provided an alternative sanction to execution for simple homicide, which came to be known as manslaughter. Wow! The conviction rate went up, and the previously high rate of self-defense verdicts went down. Because people preferred to be convicted of the lower charge and go get branded and spend a year in prison, right? Versus take your chance with murder and go with self-defense, affirmative defense. That's what that means. Wow. The percentage, that sounds just like how they negotiate plea deals, right? The percentage of offenders condemned to death over this period remained about the same, preserving over time the jury's unique role as arbiter of the community sentiment. And now you can see where this is going, right? The community sentiment, right? The common standards of decency and whatnot, right? In the 16th and 17th centuries, okay, we are now moving on up in time. 16th century is one of my favorite centuries. I happen to love the Tudor history. Not going to go on a tangent there, but just say that and move on. New legal distinctions between capital and non-capital alternatives allowed the jury to do the work of deciding who was fit for execution. Many of those indicted for grand larceny were, by virtue of the jury's undervaluation of the goods stolen or their own plea of guilty to a lesser offense, convicted of petty larceny, which was not capital. Wow. Just as some of those indicted for murder were mercifully convicted of manslaughter. Convictions were high in those capital felonies that had long been viewed as particularly heinous. That's where we get to the hack, right? Heinous, atrocious, and cruel. Y'all know how I feel about that. Particularly heinous, and in those non-capital cases that had come to serve as catch-alls, much as self-defense had in earlier times. Wow. Thus, in common law England, the jury played the role, still relevant today, of deciding whether the culpability of the prisoner is so serious that the ultimate penalty must be sought and imposed. History is always relevant, right, guys? Right here. This is literally still, here we are, centuries later, still, right? This is literally the languaging in all the discussions surrounding the death penalty, and it's just incredible. Heather's here. Hello, Heather. Yay. Yay. Heather, did you see that I made a command for Twizzle Stick, for Twizzy and the Hizzy? I don't know if he's still here, but there's his command. Okay. During the founding era and before, English society generally saw the jury's exercise of merciful discretion as appropriate, rather than a nefarious species of nullification. Wow. Bam. Let me read that again, guys. During the founding era and before, and right now we're in the, where are we? We're in the 16th and 17th centuries, okay? English society generally saw the jury's exercise of merciful discretion as appropriate rather than a nefarious species of nullification. In fact, while the jury held the ultimate power, the bench itself frequently encouraged juries to undervalue goods and convict the defendant of a clergyable offense. In other words, remember, the clergyable offense is like a lesser charge, essentially, like equating, like, for example, manslaughter versus murder, but it was all related to the church back then, which is why it's called clergyable. Anyway, out of compassion, to do rough justice in cases where the punishment would have appeared disproportionate to the culpability of the offender. This is so fucking interesting. And, I don't know. Does anybody else cover this shit? Like, it'd be easy to be like, oh, it's 31 pages long. Like, I don't know that anybody's covered this, but if you don't go through this, you miss this. This is incredibly fascinating and important. And you just see how, and again, if it started out in the Middle Ages, it started out in what, the 12th, 13th century, and humans, everything was so completely different in the world, except humans were the same, and humans were considering the same shit that we are talking about today. It gives me goosebumps. As Green explains, so long as the sanction for felony remained so severe and so long as it applied, at least in theory, to a large field of cases, the very nature of the trial was bound to be seen as related to the concept of merciful verdicts. And of course, the nature of an English criminal trial required unanimous verdicts. Bam. Such consequential matters were never decided by a bare majority. Wow. American juries at the time of the founding, again, after my violin was born, continued to play the pivotal role in the execution decision. Yeah, so my violin, so 1776. So my violin, 57. My violin is 19 years older than the country. As the United States Supreme Court has recognized, unanimous juries played an exclusive role in capital decisions in our new nation, too. Oh, my God. My God. By George. Sorry, I'm such a weirdo. Look, North Carolina case law. Woohoo. Yay! Woohoo! Shout out to North Carolina case law. And it went to the Supreme Court, even cooler, from 1976. In Woodson, woo! North Carolina. The court observed that at least since the Revolution, American juries have, with some regularity, disregarded their oaths and refused to convict defendants where a death sentence was the automatic consequence of a guilty verdict. Juries' refusals to return verdicts of guilty to avoid the consequence of execution drove the movement behind reducing the number of capital offenses and to separate murder into degrees. Yep. Heather saying not many people read these, only a few, but most usually read one case. Okay, yeah. So that's why I'm very committed to the cases that I cover, right? And in any of these cases that I'm doing pre-trial through trial, I ended up not on purpose, but I've ended up in like this with like death penalty bonanza, if you will, right? Because like I'm covering Casey Anthony gavel to gavel still, but so I've got that, right? And then BK and then this and Mario co-defendants, right? But I read every single death penalty motion for BK, and I'm reading all of them for this. And for Chad Daybell also, I covered all of the death penalty stuff ever since he was sentenced. I covered those. There weren't that many documents, but that was kind of, I think in chronological order, that was the first one. And that was like, it was like right after that, or pretty soon after that, then all the BK motions. So that was like my delve into this whole thing, but I'm really committed to, but not just the death, every document, right? I read them all. So, but most people seem to for some reason, don't place as much importance on the death penalty motions. And I don't understand why. I just don't know if it's because it's controversial and they don't want to cover. I don't know. I just don't see a lot of coverage about it. And it's like, if anything, it's probably some of the most important, pleadings. So anywho, the first reform was for the state to limit classes of capital offenses. Even then, juries would refuse to convict murderers rather than subject them to automatic death sentences. The next step, led by Pennsylvania in 1794, was to separate murder into degrees and confine mandatory execution to deliberate and premeditated killings. Juries, however, continued to find the death penalty inappropriate in a significant number of first-degree murder cases and refused to return guilty verdicts for that crime. The next set of reforms came in the antebellum era. Oh my God. By the turn of the century, 23 states plus the federal government had adopted the practice. Yeah, the question of mercy was thus exclusively reserved for the jury. It was for the jury alone to weigh in its decision age, sex, ignorance, illness, or intoxication, of human passion or weakness, of sympathy or clemency, or the irrevocableness of an executed death sentence, or any other consideration whatsoever. At the end of World War I, all but 8 states, Hawaii and the District of Columbia, either had adopted discretionary death penalty schemes or abolished the death penalty altogether. And on previous live streams, we've actually gone through the entire map of the US and looked at every state and their history as it pertains to the death penalty. I don't remember which live stream, but it's time-stamped, as everything always is. But I think it was this case, not BK. I'm pretty sure it might have been part 1 of the death penalty motions for Shanna Gardner, I think. So then the historical record establishes that the right to a capital sentencing jury included the right to unanimity. Case law here. Hearst is best read as restoring something basic that had been lost. At no time before Furman was it the general practice in the United States for someone to be put to death without a unanimous jury verdict, calling for that final punishment. Overlooking the role juries played in capital sentencing before Furman and its progeny altered the status quo would be ignoring nearly 200 years of our nation's customs and traditions. And to that end, hundreds more years prior in England, if we go back further, as I love doing. Top Cat, glad you're here, my friend. I know you're probably waiting. It's going to redirect you all, by the way, because we're almost done here. It's going to redirect you guys in just a minute over to the next live stream, which is Katie McBanaw's proffers. So awesome. I'm happy to, yeah, I'm glad that it's abolished. That is good. Very good. I have many thoughts, as you guys have heard me, I'm sure, before. But yes, so okay, the Sixth Amendment. Right. It was against this backdrop that James Madison drafted and the states ratified the Sixth Amendment. Wow. And there we go. Both long before 1791, and the system inherited from England and practiced in the early colonies and states, and after 1791 in the states as they began their own systems of criminal procedure. And indeed, up until very recently, juries decided if a criminally accused would live or die. Juries decided the question of execution. And juries were understood to mean unanimous juries, except in the 2 states whose tolerance of non-unanimity survived after Apodaca. Our history and tradition can support only one conclusion, that the unanimous jury right guaranteed by the Sixth Amendment and Article 1 of the Florida Constitution includes the right to a unanimous jury on the capital sentencing decision. This is a beautifully written document. This is powerful, really well written, all the case law, incredibly organized. I'll almost get emotional, which is just so nerdy of me, right? About how I feel about this document. And I will say all of these documents for Shanna Gardner for the death penalty, some of them necessitate more argument and have more, background and content. They're all, they're different, right? They have different things that they're going through. But the ones that have where there actually is more of this context and they really are explaining the history or they have a really specific argument, they're exceptional and I think more persuasive likely to a court even than obviously, right, in BK's case. I thought those documents were well done, but these, for me, not that it's a contest, but these are really, 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 really well done, and I think very I think they're awesome. So there we go. To avoid a violation of all constitutional protections, this court should require jury unanimity on all findings necessary for a sentence of death. And dun 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 dun. Out of wait out of four. And with that, we have finished all the death penalty motions. We are almost done here for this stream anyway. Like I said, here's the most recent filing for Shanna Gardner. This actually just got filed today. Cross notice of taking deposition. On January 24th, big day in the world of law, the defense will take the deposition of the following named persons. And these are the persons. So, there you go. But on the next Shanna Gardner live stream, y'all get ready. This, bam, the big papa, big mama, a big document, 250 pages. So we'll go through this in, I'm sure I have every intention to do every page, and it will be a project over multiple live streams, which is fine because in this case right now, like I said, with Shanna Gardner, there's nothing happening on the docket right now. There's no upcoming hearings scheduled. There's not been a lot of activity. We're going to be waiting to hear when they're going to have oral argument on the death penalty motions, but honestly, it's perfect opportunity to go through this and in installments. So that's what we will be doing. Look at that. Hey, Victorine, glad you are here. Welcome, welcome, welcome. I agree. Man should have no voice in deciding the gate of another human being. I agree. Or fate. Yeah, fate. Yes, I agree. I guess I read that and I interpreted that. I autocorrected. Yes, fate. Yeah, I agree. I agree. But also, you know, there's also the hypocrisy of it, right? Anyone that, if you've been here, you know that I have no tolerance for two things: ignorance and hypocrisy. Probably hypocrisy is in first place of those two. But you know, the hypocrisy of like, you know, if you kill somebody, that's wrong. So we're going to kill you. We're going to kill people who kill people to show people who kill people that killing people is wrong. You know, so I'm glad you had fun. Well, the fun is just beginning. It's only just beginning, because right now we're going to be redirected into the next stream magically through the powers of the internet, if it works. And every time I've done it, it works. So yes. So, okay. So now I'm going to roll the outro just to, you know, so it's like an official end to the live stream, but it should redirect you guys momentarily. So let's roll the outro and yeah, see y'all in a moment here.